we have our Yakima County Prosecutor, Joe Brusic, on the phone with us this morning. Good morning, Mr. Brusic.
Good morning, gentlemen. How are you both doing?
Doing well, Joe. Thanks for your time this morning. I know you're a busy guy.
Yeah, definitely.
Well, never too busy to address these important issues that affect all of us in our community.
Well, Joe, we were talking, we're talking specifically this morning about the case in which a man was shot while working in his yard on West Chestnut Avenue last Sunday. You have charged the alleged shooter, a 19-year-old guy, with first-degree assault and drive-by shooting. Another 22-year-old man accused as the driver, rendering criminal assistance charges. Some people have questioned as to why you're not charging that shooter with attempted murder instead of first-degree assault. So in these kinds of cases, I guess these kind of charges could apply to the many drive-by shooting cases that we have. So kind of explain the charges. Why not an attempted murder charge?
Well, first of all, I know a lot of people, especially on social media, have asked the same question, and I appreciate you asking that question this morning. It's important for people to understand we as prosecutors always are evaluating the facts of any submitted investigation and trying to always charge out the most specific crimes that we can. In this particular case, and under oftentimes these circumstances involving, say, a drive-by shooting, what we look at is what gets us the most bang for the buck, so to speak. And in this particular case, under these set of facts, first-degree assault is a more specific charge. Attempted murder is a very good charge under certain set of facts and appropriate to charge that out. However, it is more difficult to prove because we have to prove that the person intended to commit a specific crime, in this particular case, murder. A criminal attempt is defined as such, taking a substantial step towards a specific crime. And so we have to get into the mind of the shooter that he wanted to murder an individual as opposed to merely assault him. Now, obviously, attempted murder and the aspect of murder has a much richer sense to it in terms of what is known as justice in this particular case. This is a tragic shooting, and the community is in an uproar over this, and our great office is certainly understanding that. But when we look at the charge of this particular case, we look at first-degree assault, attempted murder. It's easier to prove first-degree assault, and you get relatively the same type of sentence because attempted murder is you have a completed crime, say in this case first-degree or second-degree murder. You have a certain standard range within the SRA, the Sentencing Reform Act 1981, and we have a definitive grid that we follow, as does the court for sentencing individuals. And so when we look at a completed murder case, we have a certain standard range of months for first-degree or second-degree murder. For first-degree murder with no priors, you're looking at 240 to 320 months of confinement in prison. For an attempted crime, you only have 75% of that standard range. So say if we were to charge him out with attempted first-degree murder, his standard range would not be 240 to 320, it would be 180 to 240. An attempted second-degree murder, you have a standard range of 92.25 months to 165 months. Well, what does that mean? Essentially, you're looking at a lot of time, but for first-degree assault, which in this case would be easier for us to prove beyond a reasonable doubt to a jury, his standard range with no priors, and once again, I'm not saying he has no priors or not, just in general, that somebody that is charged with first-degree assault with no priors is looking at a standard range sentence of 93 to 123 months.
Oh, there you go. Wow.
So there you go. So if we were to charge out attempted second-degree murder, we don't really get necessarily any more time, and it's harder to prove.
Yeah.
So we look at it as what is in the best interest of public safety for the community, and what is the best chance for us to get a conviction to send someone away for the longest amount of time.
Well, there you go. Yeah. Yeah, I guess that's pretty simple there.
Good explanation, John.
Yeah. I mean, for lack of a better term, I mean, attempted murder sounds better, I guess. But geez, that fully makes sense. So, in other words, you'd have to get into the mind of the shooter.
That's right.
You'd have to.
You look at first-degree assault, and first-degree assault, we have to prove that someone was assaulted. And the person who, say in this particular case, assaulted him with a firearm intended to inflict great bodily harm. Well, great bodily harm also takes into account that what if he shot head high and missed him completely? That's actually still a first-degree assault because he intended to inflict great bodily harm by using a firearm to shoot at him in the way that he did. In this particular case, he actually connected and shot him and obviously grievously hurt him. But we look at what we can prove in terms of the elements. Each and every element of every crime that we charge out, we have to prove beyond a reasonable doubt. And the facts and the law have to converge for us to try to get the best charge on the table for a judge or a jury to find someone guilty.
Let me put it in poker terms, Joe. When you're sitting down at the poker table and you see what's in the pot and how much you've already anteed to be in there and what the odds are of you taking this based on a certain I don't know what I'm talking about with poker, Joe. But basically, you have to choose as you said, that gets you the most bang for the buck. That's why we see cases sometimes that they charge in federal court instead of state court because the nature of the punishment potential is better.
That's right.
You're always kind of like weighing the scales as to what can bring about the greatest sense of justice in the public's mind, whether we understand the terms or not.
That's right. Well, once again, we have the advantage, and sometimes, unfortunately, of knowing the facts and a lot of the facts that the public doesn't know. So they jump to an emotional conclusion, which we truly understand, but we still have to stay on course to be able to prove a case beyond a reasonable doubt, because ultimately it doesn't matter what you or I believe. It only matters what we can prove. And that's an important distinction in every case. Let me give you an example. In this case as well, the alleged driver of this vehicle is charged currently with rendering criminal assistance, which is a felony, but people have asked, well, why not charge him as an accomplice to first-degree assault? Well, here's the problem. We have to be able to see facts that right now only elicit a charge of rendering criminal assistance because we have to be able to prove that he was an accomplice to first-degree assault. And there's things that we look at to determine if we can charge that out as an accomplice to first-degree assault as opposed to the more specific charge for which the facts and obviously probable cause has been found by the court for rendering criminal assistance. So even though people would want him to be charged the same way as the alleged shooter, and once again, both these individuals that have been charged are presumed innocent under the law, and that always needs to be made clear. But we look at what we can prove based upon the facts that are investigated and provided to us, and then what is the law? What is the charge that we can prove? And, obviously we are entrusted to be able to make the right ethical decision at all times, to be able to charge someone with a crime and to have not just probable cause, but eventually have trial sufficient facts to be able to ask a trier of fact like a judge or a jury to find someone guilty beyond a reasonable doubt.
Simple enough. Very well. Joe, are you hearing anything, hearing from anybody about these drive-by shootings? Are you hearing from people that say they're concerned about their safety?
Absolutely. One of the most important reasons that I loved being asked to be on this morning was because I want to let everybody know that we in the prosecutor's office hear everything that is being said. We want to work hard for everybody. We understand these are extremely serious. I mean, we had the shooting yesterday at 12:30. Yeah. We had another shooting last night at about 5:30. Another shooting, 16th and Nob Hill. An individual is hurt and obviously in the hospital over that. So, the reality for us is that we're working extremely hard. We're working very hard. We have an excellent relationship with the Yakima Police Department, with the Yakima County Sheriff's Office, with all the departments up and down the valley. And our goal is to successfully and aggressively prosecute. And a lot of people on social media are saying that we're going to let everybody down, that we're not doing our job, that we're going to let them off. The judges, the court system are just going to slap them on the wrist. That's not accurate at all. That's wrong. And I say it very, very strongly because I want everybody to know we hear what you're saying. We understand these are serious. We're going to do our damn best to get these convictions on your behalf. And I want everybody to understand that we're not going to let people down. However, we have to ethically take into account the facts and the circumstances of every shooting. It's not just a matter of sentencing someone to the maximum every single time. It's just not that simple in the criminal justice system. And there are protections in the system for everybody, not just for these individuals that are charged, but for everybody to make sure that we do our job and do it ethically and correctly.